Good morning, everybody, and thank you for joining us for this press conference marking the 8th anniversary of Dr. Hassan Diab's extradition and the calls for the government to end this miscarriage of justice. Bonjour tout le monde, merci beaucoup de nous avoir rejoints ce matin pour cette conférence de presse à propos de les efforts pour la justice pour le Dr. Hassan Diab. Today's press conference will be in English, but feel free to ask questions in French, and we have people who can answer in French, or sorry, I should be saying this in French. La conférence de presse sera en anglais, mais si vous avez des questions en français, s'il vous plaît, n'hésitez pas de les demander en français. Nous avons des présenteurs ce matin qui parlent français aussi, et on peut aussi traduire. My name is Tim McSorley. I'm the National Coordinator of the International Civil Liberties Monitoring Group. I'm joining you from Ottawa, Ontario, on the unceded territory of the Algonquin Anishinaabe people. I'd like to acknowledge that the Anishinaabe people are the original guardians of this territory, and we thank them for their stewardship of the land. We welcome the resistance and resurgence of Indigenous peoples as part of the decolonizing process. We're very proud at ICLMG today to be hosting today's press conference, and I'll soon pass it over to Roger Clark of the Hassan Diab Support Committee, who will chair today's press conference and introduce the speakers. But I just want to say first that I remember the powerful and emotional moment when Hassan returned to Canada and was freed from prison in France. The fact that France would now proceed to trial is the height of political cynicism and scapegoating, and we're proud to stand with Hassan to call for no new extradition to France and to call for the end to all charges against him. With that, I'll pass it over to Roger for the rest of the meeting.
Thank you, Tim, and welcome everybody. I have a few opening remarks to make and introduce the speakers, but I also want to mention that we have with us today Neve, who is an associate professor at the University of Carleton. Her specialization is on extradition, and she has written extensively about that. And we have with us also Marianne Higgs, a longtime activist, lawyer in Kingston, and who has been part of the Hassan Diab Support Group for many years. The speakers that we have today, there will be 4 presenters. The first will be Joe Wood, who was a professor of psychology, I think, at Carleton University, but a well-known activist in Ottawa on many, many fronts. I won't list them all because there are just too many, but Joe is a faithful supporter and also a good friend of Hassan Diab and Rania, his wife, and the 2 children. And so she will speak first. The second speaker will be Alex Neve, formerly Secretary General of Amnesty International Canada, and now lecturer senior fellow at the University of Ottawa, and works with the Graduate School of Public and International Affairs. Third speaker will be Rob Currie, who is professor of transnational criminal law at the Schulich School of Law at Dalhousie University, and one of the authors of the Halifax proposal, which some of you will have come across already, but it can be made available too. This is a key document for the future of extradition reform in Canada. And the 4th speaker will be Don Bayne, who has been Hassan's lawyer from the earliest days, an absolute stalwart, and not enough can be said about the work that Don has done in the protection of Hassan Diab. So a few general comments that I would like to make first. Some anniversaries are celebrations. Today is not one of those. Exactly 8 years ago, on the 14th of November 2014, a Friday, Hassan Diab was under arrest and on a plane to France. He had spent over 5 years appealing against his extradition. He would spend the next 38 months, 3 years and 2 months, languishing in a French prison, much of that time in solitary confinement. He was never charged, nor was he put on trial. Quite the opposite. After more than 3 years, the two anti-terrorist investigating judges responsible for his case concluded that there was no evidence to justify bringing Hassan Diab to trial. They ordered his immediate release, and Hassan returned to Canada 3 days later on the 15th of January, 2018. I'd like to recall three key statements which were central to Justice Maranger's June 2011 decision to order Hassan's extradition. First quote, I found the French expert handwriting report convoluted, very confusing, with conclusions that are suspect. Second quote, the evidence that tips the scale in favor of committal is the handwriting comparison evidence. And third quote, the case presented by the Republic of France against Mr. Diab is a weak case. The prospects of conviction in the context of a fair trial seem unlikely. And this was 11 years ago that was stated by Justice Maranger, who had gone through the case in great detail, had listened to many submissions, but nevertheless decided that Hassan Diab should be sent to France. On the handwriting evidence, very quickly, as we know now, the so-called handwriting evidence has been discredited, not only by the international experts testifying on Hassan's behalf, but conclusively by a final expert analysis commissioned by the French Court of Appeal itself. Without the so-called handwriting evidence submitted by France in its extradition request, Hassan would never have been extradited, would never have endured the torment of the last 15 years, and would be free of the anguish still suffered by him and his family. In spite of all this, the specter of a trial in the French anti-terrorist court next April hangs still over Hassan Diab. So without further ado, I will ask first speaker, Joe Wood, to please make a few remarks. Thank you, Joe.
Thank you, Roger. Yeah, I wish to reflect on the impact of this ongoing nightmare for the Diabs, already 14 years long and counting. Today's reality, as mentioned, is that Hassan will be on trial in France in April for that 1980 bombing of a Paris synagogue. It happened at a time when he was taking exams in Beirut, as has been well established. While there is not a shred of evidence against him, he cannot, based on past experience in the political climate, expect the outcome of this trial to be fair. Fear and dread weigh heavily, made worse by the federal government's silence in terms of protecting him from further extradition. Why won't they speak out? Will they cave in to another extradition request, this time to have Hassan serve a life sentence? Silence ratchets up the fear. This situation continues the persecution of an innocent man for over 14 years. Every time there is a glimmer of hope, it is quickly followed by further persecution. As mentioned, we had a joyous moment when he came home, but within a day or two, there was an appeal of his not standing trial, which led to this trial that's coming up. This kind of cruel reversal happens time after time and leads to hopelessness and despair. Every time it cuts more deeply. Is there no end? And now the looming trial also brings a huge financial burden that feels impossible to meet. Yet in the face of all this, Hassan and Rania have not been crushed. Their courage and resilience are amazing. After every setback, they pull themselves together and normalize their lives, showing little of the impact this weight has on them, although of course it is there. Aside from meeting with lawyers in the support committee, they do not otherwise keep their concerns on center stage. Instead, they make daily life positive for their two lovely children, Jenna, who is turning 10 tomorrow, and Jad, who is 7. The Diabs are wonderful company to their friends. They refuse to give up or be seen as victims, though they truly are. My wish is that Prime Minister Trudeau will speak out now and reduce their uncertainty and stress by vowing to protect Hassan from further extradition. What keeps him silent? Thank you.
Thank you very much, Joe. I will now ask Alex Neve to make his remarks, please.
Thank you very much, Roger, and good morning, everyone. What a somber anniversary today is, and it certainly is one that we should have no occasion to mark. 8 years since Hassan was unjustly extradited to France. By any measure, his ordeal should by now be long over. After all the allegations against him, which were already so weak and tenuous at the time, have entirely collapsed since November 2014, and much of that has been due to the diligent investigations of French judges. The charges were, after all, dismissed. He was, after all, able to return to his family here in Canada. Yet still, the travesty of injustice advances in France. It seems that there is no space for truth, evidence, common sense, fairness, or respect for fundamental human rights. Only the zeal to ensure that someone faces a trial for that harrowing 1980 synagogue bombing, even if that is an innocent man against whom there is not a shred of credible evidence. Canada cannot stand by. Yes, this is France, a close friend and ally with what is often described as a sophisticated justice system, but a friend that would not return the favor and extradite one of its own citizens to Canada, even in a compelling case with extensive evidence, as has been demonstrated recently in the case of the retired French priest, Johann Rivoire, accused of sex crimes against Inuit children. His extradition to Canada has been barred. And friend or not, Canada's primary and overwhelming responsibility is to defend the human rights of its own citizens. That means taking a stand against any further wrongful, unjust extradition and making that clear now to give Hassan Diab and his family some peace of mind. And it should mean going one step forward and communicating to the French government that Canada considers the ongoing prosecution of Hassan Diab to be unfounded and unjust and expects French authorities to bring it to an end. Thank you.
Thank you, Alex, very much. I'll now pass the microphone to Rob Currie.
Thank you, Roger. Over the last few years, I've had the privilege of being involved with a very serious law reform effort. And it's a law reform effort directed to Canada's extradition laws and practice, by which I mean not only our Extradition Act, with all of its well-known problems, but also Canada's treaty relationships and the way that those treaty relationships are dealt with and arranged. I think I can say quite safely that this law reform effort is easily premised on one point, which is that a legal system that would result in the horrendous situation that we've seen Dr. Diab and his family being placed in is a legal system that needs to be changed and to be reformed. The fact that our extradition laws produced the extradition of Dr. Diab is evidence enough that there is a need for change. There are other cases, a number of which we could speak to in the questions if you like, but the central idea the last number of years has been to urge Parliament to engage in a serious study and overview of the Extradition Act and of extradition practice, and really make the fundamental changes that are required, because we've seen that the courts cannot do much more than has been done, even applying the Canadian Charter of Rights and Freedoms to the Extradition Act. So really, the time is right for parliamentary reform. Any number of you will be familiar with the Halifax proposals that Roger referred to. They were released last year, and they were the result of a high-level conference that was held in Halifax in 2018, with the goal of producing not just an effort to agitate the government towards change, but to engage a serious law reform conversation. And the proposals themselves are premised on three fundamental pillars, which are that, first of all, the extradition process, like all of our legal processes, should be fundamentally fair. It should be fair in procedure. It should be fair in substance. And there are serious deficits that need to be remedied. Second, that all of Canada's extradition laws and practice should be the subject of transparency, and there should be mechanisms of accountability and oversight in place, which are simply not there. The fact of the matter is, the government is extremely and at times needlessly secretive about all of Canada's international cooperation efforts, and that needs to be changed. And third, that there needs to be a rebalancing of roles in this context, both between the courts and the government. So those roles need to be redistributed, but also between the protections that are inherent in the Charter and the administrative efficiency that is sometimes touted as the major goal behind the extradition process. So the Halifax proposals are, again, a serious law reform proposal. We have been making effort to initiate the conversation over the last year in particular, but the last number of years. And I'm very pleased to say that, as Jim Bronskill reported in the Globe and Mail this morning, the Standing Committee on Justice at the House of Commons is embarking on a study on extradition reform. No sign yet, I don't think, when that's going to commence, but that has been passed. There's a serious proposal to examine it. And certainly we will be participating if asked to, and continue to make submissions along these lines. And again, hopefully just engage Canadians who have been left out of this conversation in this process of looking at our laws, scrutinizing them, and trying to make them work both effectively and fair. Thank you.
Okay, thanks, Rob, very much. And our last presenter will be Don Bayne. Don?
Thank you, Roger, and thank you, everybody participating and those attending, for helping us try to shine some light on the darkness of injustice of this case and, quite frankly, many other extradition cases. Hassan Diab's case is really a case of significant wrongfulness in the treatment by Canadian and French legal systems of a demonstrably innocent man. Let me give you some reasons for that. A, the original extradition was legally improper. It was illegal. The Supreme Court of Canada, prior to the Diab decision here in Ottawa, had stated, well, the whole purpose of the extradition is to send the person sought to the requesting country for trial. To send the person there to languish in prison without trial is antithetical to the principles upon which extradition and the comity that supports it are based. And yet, when this was argued to the Ontario Court of Appeal, and it was clear the French did not intend to try Hassan Diab, this was extradition for investigation. The court stated in a heartbreaking statement, it is clear to us that the appellant, Dr. Diab, will not simply languish in a foreign jail. Well, 3 years plus of solitary confinement proved that drastically wrong. This was a legally improper extradition in the first place for investigative purposes. Secondly, it was based on demonstrably unreliable evidence, a handwriting opinion, nothing else. That was the sole basis on which Dr. Diab was extradited. It was unreliable then, it's unreliable now. Every renowned world expert came to testify that the handwriting opinion of the French was completely unreliable, as it didn't apply appropriate handwriting analysis methodology. As has already been mentioned by Roger, the French Court of Appeal, seeking to buttress that opinion during the appeal proceedings, commissioned another investigation of that handwriting. And the French experts hired to do that reported, we agree entirely with the defense experts that this is and was a totally unreliable opinion. So the man, it was an illegal extradition based on evidence that was completely unreliable, even the French admit. And what we just learned thirdly, and it's very upsetting and should greatly concern the Canadian government, is the original French description of their case said there was no fingerprint evidence available in the case. The bomber who signed in at the hotel in France in September of 1980, they said, left no fingerprints on the hotel card that he signed in with. In fact, that was not true. The French knew it was not true because previously their handwriting experts had identified a fingerprint on the card, had compared it against multiple people worldwide, including Hassan Diab, and it was scientifically not him. It's somebody else's print. France lied about that, and the Canadian court erroneously was led to believe there was no fingerprint evidence, against which there would only have been handwriting evidence. That's a very significant factor. So this is a case, an odyssey of injustice, multiple illegalities. We know he returned to Canada, and there were noble efforts at that time by our government to have him return. And I credit in particular Minister Freeland for her efforts in that regard. On his return, the Prime Minister promised that what happened to Hassan Diab never should have happened and must never be allowed to happen again. Pressure by multiple groups in France has caused France to undertake a trial contrary to the finding of its own professional investigators that there was no case against this man, no evidence. In fact, the available evidence proved conclusively that he was a completely innocent man. So what are we going to have now from a legal point of view? A show trial, a political trial, and an unconstitutional trial. This will be, the French are proposing, a trial in absentia. In Canada, that's not allowed under the Constitution. An accused must be present at every aspect of her or his trial. So what is now France is doing is conducting, by Canadian standards, an unconstitutional trial for political reasons to satisfy pressure groups who want somebody, and in this case, Hassan Diab, scapegoated for an event that happened over 40 years ago. What are Hassan's options? They don't exist. It's to remain a pawn between two states, two governments. He's vastly outnumbered in resources, financial, legal, on every scale. And yet he's a demonstrably innocent man. The time has come for the Prime Minister and this government to honor their undertaking to Canadians and their duty to protect Canadians, that this must not be allowed to happen again. Nobody can be assured, reading the decision of the French Court of Appeal, which is an embarrassment, quite frankly, to reasoning, to legal judicial reasoning, that Hassan would not be convicted at this trial in absentia. And that will produce the French coming knocking again for another extradition request so they can imprison the man they have unjustly convicted, even against their own professional investigators' evidence. It's time to do something about this. Thank you all for listening. Thank you for shining the light of truth into the darkness of this case.
Thank you, Don. And before I pass it over to Tim to moderate the questions, I just want to say that there is a lot of politeness. We've heard ourselves speak comfortably, politely, rationally, reasonably, but we're at a time where outrage is also justified. We are now 5 months away from this bogus sham trial in France. There is nothing to justify that. You've heard all the presentations, you've read the material, you know the problem. But the time has come for people to show that outrage as well. It's great to be polite. Our society works with politeness and courtesy and respect. But Hassan Diab deserves that also. And that's what's missing right now. So I'll hand that back to you, Tim, for the questions.
Thank you, Roger, and thanks everyone for those powerful statements. We'd ask now that if journalists have questions to raise their hands. First, we have David Cochran. If you'd like to unmute yourself, and feel free to turn on your camera if you like, or you can leave it off as well.
Hi, I'm going to leave the camera off just because I'm in a weird spot. We'll just leave it at that. I wonder, Mr. Bayne and perhaps Mr. Neve, if you can speak to the Revoir extradition case for a second. I know, Alex Neve, you mentioned it in your comments, but I'm wondering how you think the government of Canada should use that. Because one of the arguments from France, aside from the citizenship issue, was that the crimes were committed in 1979, or the alleged crimes, and that is too old under French law, yet the Copernic bombing was in 1980. And so I wonder if those arguments can be used in any way to support Dr. Diab's cause, and how would you like the government of Canada to use them in this?
Alex, you go first.
Well, I think the Canadian government should absolutely be using that case to maximum advantage. And it's not to suggest that we in any way take a position that somehow Revoir should not be extradited to Canada. Do not get us wrong. There are grievous issues in that case, and there's a very strong evidentiary record. And I personally am very supportive of the calls from Inuit survivors and communities that extradition should go ahead and that there should be justice. That said, at the same time, I think Canada should be highlighting to French authorities the double standards and hypocrisy that seem to mark their approach to these two cases. And if anything, it should certainly reinforce Canada's arguments that fundamental justice requires Canada to take a stand here and to oppose the extradition. Over to you, Don.
David, I would say that Revoir is simply the tip of an iceberg of hypocrisy. Revoir may be partly based on the fact that it was so long ago. And as you point out, ironically, it's the same time period as the bombing in France. So the same argument would apply to the Diab case, but France chooses out of expedience to ignore that. The greater problem is that in every single French extradition request, there is the hypocrisy of a lack of reciprocity or comity, on which the Supreme Court says extradition is based. France will never extradite to Canada a French citizen, yet repeatedly and with a straight face asks Canada to extradite a Canadian citizen to France. France will say, if you want a French citizen tried, we'll try him here in France under the French system, and you send us your evidence. Justice Moranger at the Canadian extradition proceeding, when we raised that with him, said, you know, Mr. Bayne, what I would do with this case if this was here before me. France doesn't want to trust the Canadian justice system, and so instead pursues this hypocrisy. We won't send you, Miss Father Revoir, but we want you to send us Hassan Diab. It's hypocritical, and it undermines the basis on which extradition is said to exist, comity and reciprocity. There's no comity, there's no reciprocity with France.
Could I just ask a quick follow-up?
Yep, go ahead.
I just wonder, has there been any update from Apolline and the other lawyers in France representing Dr. Diab as to where this is procedurally, if it is 100% set to go in April as expected? Because with this case, when it looks like something is going to happen, it often does not. I just wonder if there's been any sense of whether this is full steam ahead to the retry starting in the spring.
David, you know that Yogi Berra said the future's hard to predict because it hasn't happened yet. But I have every indication that this trial is 100% set to go.
Can I jump in there, Tim, just for a moment? I fully agree with everything Alex and Don said. And David, Canadian government officials and diplomats are constrained from saying certain things, but I think my own take on it is that France is not a good extradition partner for Canada for all of the reasons that we have that we've indicated here and others. There are other extradition cases and matters languishing in Canada's courts involving France that are sort of bubbling up. And France is well known to have problems along the lines of literally human rights standards in their criminal procedure. It's been criticized by credible human rights organizations for delays in particular, also for other forms of unfairness. And the last time Canada encountered an extradition partner that had significant human rights issues was with Hong Kong. And the government's response was to suspend our extradition treaty with Hong Kong. Admittedly, the problems were different. They were political, but they were human rights problems nonetheless. And I've written and I've proposed before that one option we've got here for Canada to get France to take this situation seriously is to suspend the extradition treaty. And maybe that would help to engage the government of France in a more serious dialogue than it has been willing to have to date.
Thank you, everyone. Next, we'll go to Jim Bronskill with a question.
Thanks, Tim. I just want to, on the logistical side of this, if I understood Don correctly, there's been no extradition, renewed extradition request. And I'm wondering if there would be one, when exactly that would come. If I understood you correctly, the sense is the future is hard to predict, as you said, but there would be a trial in absentia and then a request, or could the request, if there is one, precede a trial? How would that play out in terms of the timeline?
Jim, I think it's a virtual certainty that France now, given everything that's happened, would be finally too embarrassed to bring an extradition request before the trial. What they will do is run this unconstitutional trial in absentia. And if they get a conviction, and as I say, there's no logical basis for a conviction, but logic and reason and trust in justice fail one when you look at how France has dealt with Hassan Diab. So you can't rule out the unjust possibility of an unjust conviction. And that's when France will move to send to Canada a request for extradition saying, and extradition to serve a sentence after conviction is on the face of it easier than before conviction. So they would come back with a renewed request after conviction at trial in absentia. I hope that answers your question.
Yeah, it does. Thanks. And you've already touched on this, but has there been any formal response to any of the very clear and pointed pleas and letters that have been written on Mr. Diab's behalf since in the last several months? Anything new from Justice or from ministers to give you any sense of what they're thinking?
Nothing to me as the lawyer. I'll let the others speak for themselves.
I'm certainly not aware of anything, have not heard anything, and the extent to which there's been any comments anytime over the past year or so, it has been a variation of we are watching, we are reviewing, we have nothing to say at this time.
Yeah, I just
I would
add that maybe the small light at the end of the tunnel is the decision by the Justice and Human Rights Committee to do this review. These things are not just taken on lightly. We know that there is support from Liberal members of that committee as well as the NDP members of the committee. So there is support there. How high that reaches and how that will play out, how the Department of Justice will try to justify its decision back in 2011, I don't know, but it could make for some very interesting hearing. Other than that, though, nothing from the senior levels of government, I must say.
Thank you, everyone. Are there any other questions for the speakers? Any final statements from any of the speakers that you'd like to add?
Tim, if I might, I'd like to just make a brief comment in French, because I know that this press conference, even if French journalists are not actually present, is being followed by a number of French journalists. So if you'll excuse me, I will just say a few words. Les juges d'instruction antiterroristes, excuse me. Sorry. Excuse me. Les juges d'instruction antiterroristes français en charge du dossier Hassan Diab ont conclu qu'il n'existait aucun élément de preuve justifiant un procès et ont ordonné la libération immédiate de M. Diab. Toutes les soi-disant preuves présentées par la France pour justifier l'extradition d'Hassan Diab le 14 novembre 2014 ont été retirées, discréditées ou rejetées. Rien de nouveau n'a été produit par le procureur français. En revanche, la preuve de l'alibi plaçant Hassan à Beyrouth au moment de l'attentat de Paris en 1980 s'est avérée inébranlable. Malgré cela, le gouvernement français continue de persécuter Hassan Diab en portant cette affaire injuste devant les tribunaux en avril 2023, l'année prochaine, dans 5 mois. Il est temps de changer cette situation profondément, que ce soit une décision du gouvernement français de ne pas continuer cette injustice très évidente, ou pour le gouvernement canadien d'annoncer très clairement, surtout au gouvernement français, qu'il n'accepterait pas une demande nouvelle d'extradition de Hassan Diab. Merci de votre attention. Thank you.
Thank you, Roger. And if there aren't any final questions, we'll close today's press conference with that.
Thank you, Tim.
Thank you, everybody. Have a nice day.
Thank you all. Thank you.